Hello friends, welcome back to VOW DAYS. Welcome to the discussion of the Vision Mains test series. So as you all know, we are discussing the first test now and this is part 3. Hope you have seen the other two parts. And in this part, we are going to discuss from question number 11 to 15. So before moving ahead, a small information. Do join our Telegram channel where we will be posting all the updates with regarding to our programs and various other questions and a lot of material as well, which will help you in your exam. The Telegram channel is VOW, you can see here on your screen, and it has about 10,000 members. So if you just type VOW in the Telegram, you will just get it. And also I will give the link of the Telegram channel in the description. You can join via that link as well. So now let's quickly begin with the 11th question. So this 11th question, if you see, this is about the 73rd and 74th Constitutional Amendment Act. This question is directly based on that. As you all know, the 73rd and 74th Amendment Act deals with the local bodies, and the question is directly on that. So question on local bodies comes every alternate year, or you can say every year question in some or the other way will come on it. Okay, so that is why this is very important for us. This is very important for us. This 73rd, 74th Amendment Act, if the question is directly on that, you can directly start with the Amendment Act, when it was passed and all. Okay, so it was passed in 1993 and it gives constitutional status to the local bodies. So you can just directly start with that. And various provisions like the devolution of powers, the 11th and 12th schedules, the State Finance Commission, the State Election Commission, the District Planning Committee, okay, all these things are given. And the important issues with regard to the local bodies are the funds, the functions and functionaries. So funds, as you all know, the funds is one of the major issues of the local bodies. The funds are not devoluted, that means the funds are not given to the local bodies directly by the states. The states are stopping that. That is one of the major issue. The states, in fact, they are not setting up the state finance commissions. Okay, so we can use data directly with regard to that. Recently, the 15th Finance Commission has asked the states to devolve funds to establish the states finance commissions. That was also seen. Okay, and also another important thing is the devolution to the local bodies has increased in the 15th Finance Commission devolution. That is also there. And functions, as this is also another major issue, because there are a lot of optional functions which the state has to devolve eventually, and the states never did that. That is also a major issue. So the funds, functions, functionaries issue is always there. Okay, so despite these, actual devolution is a distant dream because of these things. The ambiguity on the functional jurisdiction is another issue. So this is something which has to be solved, and the inadequate control on the people working to implement the program is there, and also inadequate involvement of local bodies in choosing of welfare scheme, as well as in the planning. We have the district planning committees, but they are not constituted timely. The elections to the local bodies are also not held timely. We are seeing a lot of politics with regard to the local elections. That is also a major issue. Okay, so you can read all of these issues. So the way forward is implementing the recommendation of the Finance Commission, and also ensuring that the funds are devolved, establishing state finance and election commissions, both of them. Like that, we can just write the way forward as well. Coming to the quasi-judicial bodies, the next question, the 12th question, is on the quasi-judicial bodies. So quasi-judicial bodies, if you see, they are the bodies which has the power of judiciary. They are administrative bodies, but having the power similar to that of judicial bodies. These are called as quasi-judicial bodies. That means they are semi-judicial in nature. The main aim of these quasi-judicial bodies is to reduce the burden on the judiciary, because as we all know, we have more than 3 crore pending cases. More than 3 crore pending cases are there, and there are a lot of other issues with regard to the judiciary. The delays, lot of delays are happening, and also another important issue is that the Supreme Court or any other high court or the local courts, they don't have sufficient technical expertise. That is one of the major issue. Technical, especially for example, take environmental issue. The Supreme Court will not have sufficient technical expertise. So that's why we have this National Green Tribunal. It has experts from the environment field, the income tax appellate tribunals, the central administrative tribunals. So all these tribunals will have certain experts as well, who can guide. So that's why these quasi-judicial bodies, they are very much important and very much helpful. So these quasi-judicial bodies have certain similarities with the judicial bodies, like they have the full power to adjudicate the matters which come before them. Similar to courts, their decisions are binding with the provision of appeal always there. Both are manned by experts from the legal field. So the important thing is these quasi-judicial bodies have people from the field, that means the experts as well as the judges. Both of them will be there. So this is a combination, and this is a mix of both experts as well as the judicial officers. So the quality of legislation, or the quality of the quality of the judgments will be much higher. That is the major thing. But there are certain issues, certain differences. The differences, if you see, these quasi-judicial bodies, they are non-judicial bodies. Okay, they are non-judicial bodies. They have limited powers, and also so another important issue in the recent times we are seeing is the lot of vacancies even in these quasi-judicial bodies. Lot of vacancies. Okay, they have the power of the court to adjudicate or pronounce decisions, but they are not strictly bound by the procedures that should be followed by the courts. Because a lot of quasi-judicial bodies, they are not bound by CRPCs and all. Okay, they are based on the principle of natural justice. That is also there. And unlike judicial bodies, they are restricted to the area of expertise. They are not allowed to go to to enter into the other areas. These quasi-judicial bodies can hold formal hearings only if they are mandated to do so as per their governing laws. So they just like court, they will not be able to function freely. They will not be able to function freely. They have a lot of restrictions as per the law. This is there. Okay. Right. The next question is on the disqualification under RPA. This is one of the most important question. This is one of the most important question. Every year, almost every year, we will find a question on this RPA. Every year. Even in 2022, if you see, there is a question on RPA. So this is one of the most important areas, this RPA. Okay, so keep a close eye on this and just by heart it. Okay. So this RPA 1951 enacted to provide for conduct of elections to the houses of parliament and to houses of legislature. So basically this is for the conduct of elections. Okay, and also the machinery for the conduct of elections, the qualification and disqualification for the membership of two houses, the corrupt practices, everything is defined here. It also contains the provision for disqualification both for being chosen as for being the member of either house of the parliament or state legislature. That means a person can be member of either of the parliament or the state legislature. He cannot be a member of both. So the procedure, how a person can be removed and what are the choices available to him, all of these things are there in this RPA 1951, the Representation of People Act 1951. So for the disqualification, it is classified, the disqualification types is classified into criminal grounds. Section 81 states that a person convicted of an offence under the promoting of enmity between the groups on the grounds of religion, race, place of birth, residence, language, etc. This is one thing. Second, offence of undue influence. Next, offence related to rape or cruelty towards women. Next, offence of making statements creating or promoting enmity. Next, ill will between the classes and offences relating to such statements in any place of worship. So these are the various things according to section 81. And also a person convicted of the offence under the bribery or corruption or disloyalty violation of Prevention of Corruption Act 1988, he also can be removed. And there are other offences also based on which the person can be removed. The person can be disqualified. First is the practice of untouchability according to the Protection of Civil Rights Act of 1955, because even under Article 17 we have this untouchability. Okay, untouchability which is banned. So this is also there. The next one is offence of importing or exporting of prohibited goods under the Customs Act. Offence of being member of unlawful association. This is according to the Unlawful Activities Prevention Act of 1967. Next one, if a person has entered into contract with the government or for the business, or on the failure to lodge account of election expense with the ECI. So also mention this Lily Thomas case of 2013. So according to this Lily Thomas case, if there is any MLA, MP or MLC who is convicted of a crime and sentenced to minimum of 2 years jail, then he loses his membership of the house immediately. So this is there. So lot of members, Lalu Prasad Yadav, a lot of earlier Jayalalitha. There are a lot of leaders who got arrested and they were disqualified under this. So remember all of these things. Remember all of these things. And also remedies. This year the question is also this year in 2022. The question also asked about the remedies and all. So if you see here carefully this question, so it asked about the various provisions with regarding the disqualification. So under section 8.1, a person can be disqualified if he is promoting enmity, if he is under the undue influence, okay, or if he commits any crime related to rape or any untoward incident towards women, or ill will between the classes or groups, all of these things. And also if he is practicing untouchability according to the Protection of Civil Rights Act, and offence of importing and exporting of prohibited goods under the Customs Act, here we can see, and offence of being a member of the unlawful associations. So even under this he can be removed, and also violating the Narcotic Drugs and Psychotropic Substances Act of 1985. So all of these things. And also remember to write this Lily Thomas case. Under the Lily Thomas case, the Supreme Court said that if a person, if any MLA, MP or MLC, if he is convicted for a crime and he has a sentence of minimum of 2 years, then he loses his membership of the House immediately. This is under the Lily Thomas case. So you have to write all of these things. The section 8.1 you have to write about the protection of civil rights, you have to write about the section 11 of Customs Act. If you write all of these things, if you read the Lily Thomas case, definitely you will get very good marks. Okay. So next, what are the remedies for against such disqualification? This also we have to know. So there are exceptions under section 8A. The corrupt practices, ECI may remove any disqualification or reduce period for any such disqualification. So this remedy is available with the ECI. So under exceptional circumstances, the Election Commission will be using this. Next one, the person may file a petition with the President under subsection 2 of section 8A with respect to disqualification. So this is also there. So either ECI can do, or the person can appeal to the President of India. This is also there. And also the disqualified person can move to higher appellate authority for further consideration of the case. So if a person is convicted, then definitely if he is convicted by the High Court, then definitely he will move to the Supreme Court. He will move to the Supreme Court by the way of appeal. Okay. Just a second, guys. Sorry, there was a small technical issue. Yeah. So he will move to the higher court to get it solved. So that is also there. And for disqualification under corruption or disloyalty, ECI cannot issue certificate as conclusive proof of corruption or disloyalty unless an opportunity of being heard has been given to the person. So this is also there. Next, the basic structure doctrine. See, basic structure doctrine, whenever you are writing, the first thing is you will be writing the Keshavananda Bharati case definitely, but try to write the definition also. What is the basic structure? So basic structure is that structure given by the Supreme Court of India, which is based on the constitutional principles. Something like that, you can just frame a statement and have a standard introduction. It is the power of so it is the basic structure doctrine is that doctrine given by the Supreme Court to ensure that the constitutionality is maintained and the constitutional principles are followed by the government which is in power. Like that we can just write. Okay. This basic structure is basically part of the judicial activism or judicial supremacy also, you can say, because basic structure doctrine originally is not there in the constitution. Only in 1973 in the Keshavananda Bharati case this was introduced. So if you see its evolution, first in the Shankari Prasad case of 1951, so the power of the parliament to amend constitution under 368 includes the power to amend fundamental rights. This was said by the court. Because back then what is happening is there is a tussle that was going on, because the government, it want to take away the right to property, so that the government want to redistribute the land, because during the British rule and all, we had this zamindari system, the Mahalwari system and various other systems. During that time what happened is there was a lot of land which only went to the rich and affluent people, and the poor and the landless, they just remained poor because they didn't have enough land. Okay, so to redistribute, to take the land from the rich and redistribute to the poor, the government have to ensure these land reforms, and for that the government has to bring in laws. But we have Article 31 which talks about the right to property, which is a fundamental right, And under Article 32, if your fundamental right is breached, you can directly approach High Court or Supreme Court. So all of these issues are there. That's why the government wanted to amend this fundamental right. So various issues came up. So in the Shankari Prasad case, the Supreme Court said government can amend any part of the constitution, including fundamental right. This was overturned by the judiciary in the Golaknath case of 1967. The fundamental rights are given transcendental and immutable position, and Parliament cannot abridge or take away. This was said by the court. And then under the 24th Amendment Act of 1971, the Parliament has the power to, so there was a law that was passed, and it said that the Parliament has the power to abridge any fundamental right under the Article 368, and it will not be questioned by the court under Article 13, because Article 13, what it says, if any law goes against the fundamental right, then it is null and void. This is what said in Article 13. But under Article 13, the law which is mentioned, does this mean only ordinary law or even the Constitutional Amendment Act? This is another major question. So all these questions were there. Then came the famous Kesavananda Bharati case, where this 24th Amendment Act, it was upheld, and Supreme Court said that the Parliament can amend any part of the Constitution, but the only limitation is that it cannot take away the basic structure. The basic structure has all the, you can say, it is something which will be existing throughout the time, till the time we have another constituent assembly. Because what is the rationale of Supreme Court is that it is the constituent assembly which has formed the constitution, the constituent assembly. Now the Parliament is not equal to constituent assembly, right? The Parliament is not equal to constituent assembly. So there are certain principles which has to be there until the constituent assembly is again reconstituted. This is what is the major thing. So that's why, in order to protect the principles, in order to protect the various principles like the liberty, secularism, the equality, so for all of these things, this basic structure came into picture, and Supreme Court said the government can amend any part of the constitution without affecting the basic structure. So next, in the Minerva Mills case, Supreme Court included a judicial review as part of the basic structure. Judicial review. In the Vaman Rao case of 1981, Supreme Court said this doctrine will be applied to the Constitutional Amendment Acts after the Kesavananda Bharati judgment. In the Coito-Holland case of 1992, the free and fair elections was also added to the basic structure. So Minerva Mills case, judicial review; Vaman Rao case, the Constitutional Amendment Acts; the Coito-Holland case, the free and fair elections. In the Indira Savani case, the famous Indira Savani case, the rule of law is also added to the basic structure, the rule of law. And in the S.R. Bommai case of 1994, the S.R. Bommai case, the federal structure, the unity and integrity, secularism, socialism, social justice, judicial review, all of these things are made part of the basic structure, Okay, and this basic structure is something which will protect the principles on which the constitution is formed. It ensures that the majority does not change the constitution according to their own will. The Supreme Court even said in various judgments that the preamble can be enriched. That means in the preamble, various things can be added but not removed, but they cannot be removed. This is what Supreme Court said. Okay, so this is about this basic structure question. Now let's move on to the next question, the cooperative federalism. See, federalism question is another very, very important topic. Definitely you will find a question every once in a, you can say every alternate year, you will find a question on federalism. This is for sure. You will find a question on federalism. But the important thing is, you have to understand, does this federalism that we're talking about is Indian type or the Western version? So you have to have a clear idea, what are you writing? Okay. So Indian federalism is different from Western federalism. Our federalism is more of a cooperative federalism that we need, competitive federalism. So we have to state issues accordingly only. We cannot say that, we cannot say that the federalism is flawed, the federalism has issues like the power is not divided equally among the states. We cannot state those things because Indian form of federalism is totally different. Indian form of federalism is totally different. It is a federalism where all the states are treated not equally but in an equitable manner. This is also another important thing, in an equitable manner, because every state has different need. According to their own needs, various protections are provided to different states. For example, the 5th schedule, the 6th schedule and so on. right? So though there are provisions for the distribution of power and practice, these powers are to be exercised jointly by center and states, and to evolve a shared vision of national developmental priorities and strategies with the active involvement of states. So cooperative federalism basically means it's a federalism. It's a concept of federalism where the state and the center comes together and work in a coordinated manner, and they share the vision of national developmental priorities and all, and working in a cooperative spirit through the structured support initiatives and mechanisms with the states on continuous basis, recognizing the strong states make a strong nation. So you can use couple of statements in your answers, because here generally in these solutions and all you will definitely find very good statements. So try to write these statements somewhere in your copy and try to use them while writing answers. Okay. So next, but this cooperative federalism in India faces given challenges. The first is interstate council. It is seen as talk shop and its recommendations are not binding on the government. Right. Next, Niti Aayog. Though it gives significant boost to cooperative federalism, but it is not a statutory body. And the states have complained of the misuse of the office of governor because of various political reasons. This is also another issue that we are facing. And due to different states being at different stages of development, there is a sense of discriminatory treatment in the allocation of resources and all by the government. This is also another major problem. And also the finance problem that we have seen, the economic problem during COVID with regarding to the GST compensation. This is also another major issue we have seen in recent times. And also the water problem between states. This is another major thing. We all know about this Kaveri issue between Karnataka and Tamil Nadu. Okay. So like this various issues are there. So what are the remedial measures which can be taken? There are various measures using of forums like Niti Aayog, interstate council and also the regional councils, that means the zonal councils. They have to be used properly, following the recommendations of various state committees. Okay, and also the Niti Aayog's approach, where it focuses on policy formulation based on adequate data. The bottom up approach, this can be cited as an example. The balanced regional development, for example the Niti Forum for the Northeast. This also we can write. Next, strengthening of interstate councils. So as I said already, the various commissions like Sarkaria Commission, the Punchi Commission, those commissions recommendations and all we can write, especially with regarding to the governor's appointment and all. So all of these things we can write. So the way forward for this is ensuring there is cooperation among the states, and also there is competitiveness among the states. This will ensure great efficiency, this will ensure great effectiveness among the policies and all. So all of these things we can just write. Okay. So these are the 5 questions for the day. Tomorrow we will meet again and we will finish the first test, and while discussing from question number 16 to question number 20. So that will be for tomorrow. And before I leave, a small information. The document what we are using for the discussion is the summary document of the answers of Vision test series. Okay. So you can avail this. You can avail this for the first 1 week at free of cost by just registering using the given link in the description. But if you want to purchase it, you can purchase from our Telegram channel. You can contact us from there. Okay. And you can purchase the Vision Prelims test series summary at just 1199, Vision Mains test series summary at 1199, monthly magazine at 749, and the whole combo can be availed at 2499. Right. So that's it guys from my side. I'll again see you tomorrow with 5 more questions. Till then keep studying and stay tuned. Jai Hind.